State Legislative Council election. Qualifications and disqualifications from council constituencies. Disclaimer. This training material is for use in training of election officials. It should not be referred as guidelines of ECI. In case of any variance in this training material, the ECI guidelines or rules or laws shall prevail. Learning outcomes. At the end of the session, the participants will be able to understand constitutional and statutory provisions on qualifications and disqualifications, understand the various legal positions regarding qualifications and disqualifications. Provisions in Constitution. A person must be qualified and must not be disqualified under the Constitution or under any law. Qualifications and disqualifications for Legislative Council election. For Legislative Council elections, qualifications are prescribed in Article 173 of Constitution. Disqualifications are prescribed in Article 191 of Constitution. Candidature. Crucial date for determining whether a candidate is qualified or disqualified is not the date of filing nomination paper, but the date fixed for the scrutiny of nominations. Qualifications to contest an election. Qualifications to contest an election are of two types: constitutional qualifications mentioned in the Constitution, statutory qualifications framed by the Parliament. Constitutional qualifications. The constitutional qualifications as per the Article 173 of the Constitution are citizenship of India, oath or affirmation to bear true faith and allegiance to the Constitution, minimum qualifying age, any other qualification prescribed by the Parliament. Citizenship of India. Must be a citizen of India and makes and subscribes an oath or affirmation. All about oath or affirmation. Oath to be made by: every candidate has to make and subscribe an oath in the form prescribed for the purpose in the third schedule to the Constitution. When to be made? Oath or affirmation must be made after the nomination paper has been submitted to RO. It must be made before the commencement of the date of scrutiny, that is, latest by midnight of the date preceding the date of scrutiny. Oath or affirmation by a candidate contesting election from more than one constituency. Making and subscribing oath or affirmation in one constituency is sufficient if the candidate is contesting for the same house. Separate oath or affirmation is required if candidate is contesting different types of elections simultaneously. Authorities before whom oath or affirmation to be made: RO or any of the AROs of the constituency, stipendiary magistrates of the first class, district judges, and persons belonging to judicial service of the state. Superintendent of the prison if the candidate is confined in a prison. Commandant of the detention camp if the candidate is under preventive detention. Medical superintendent or medical practitioner attending to the candidate in case candidate is admitted in hospital. Diplomatic or consular representative of India in the country if the candidate is out of India. Any other person nominated by the ECI on application made to it. Please note, certificate of oath to be given to the candidate without his applying for it. If taken before a different authority, onus is on candidate to produce certificate of oath before the RO. Form of oath or affirmation in the Constitution of India. For Legislative Council election, Form 7A in the third schedule. Age qualification. Minimum age is 30 years. age qualification should be fulfilled by the candidate on the date fixed for the scrutiny of nominations. Statutory qualifications. Statutory qualifications. In addition to constitutional qualifications, the Constitution has empowered Parliament to lay down such other qualifications for membership of state legislatures as it considers and deems appropriate. Parliament can prescribe such additional qualifications under the Section 173C. These are contained in Chapter 2 of Part 2 of RP Act 1951. Definition of an elector. As per Section 21E of RP Act 1951, elector to a constituency means a person whose name is entered in the electoral roll of the constituency for the time being in force and who is not subject to any disqualification as per Section 16 of RP Act 1950. Registration as an elector. Elector in an assembly constituency of the state concerned. Disqualifications to contest an election. Disqualifications to contest an election are of two types. Constitutional disqualifications mentioned in the Constitution, statutory disqualifications framed by the Parliament. Constitutional disqualifications. Basic disqualifications mentioned in the Constitution for membership of state legislature are given in Article 191. Basic disqualifications mentioned in the Constitution are holding an office of profit under the government, being of unsoundness of mind, being an undischarged insolvent, non-citizenship of India or acknowledgement of allegiance or adherence to a foreign state, any other disqualification prescribed by Parliament. Office of profit under the government means an office which is capable of yielding a profit or pecuniary gain. Holding an office under the central or state government to which some pay, salary, emolument, remuneration or non-compensatory allowance is attached. How to test? As per Supreme Court decision in Shivamurthy Swami Inamdar versus Agadi Sagananna Adanappa, following test can be applied. Whether the government makes the appointment, whether the government has the right to remove or dismiss the holder, whether the government pays remuneration. What are the functions of the holder and does he or she perform them for government? Does the government exercise any control over the performance of these functions? Concerned state legislatures have passed Act removing disqualification in respect of certain offices mentioned therein. Please refer to Prevention of Disqualification Act of State concerned. When an office exempted from disqualification under the law, the holder of such office is not deemed to be holding office of profit, irrespective of receiving remuneration. Disqualification, unsound mind. A person is disqualified if he is of unsound mind, and such person should be so declared by a competent court under the Mental Healthcare Act 2017. Disqualification under undischarged insolvency. A person is judged insolvent by a competent insolvency court under the Insolvency and Bankruptcy Code 2016. Mere commission of acts of insolvency not a ground for disqualification. Disqualification on this account ceases to be operative if the insolvent is discharged from insolvency by the competent court. Disqualification under non-citizenship of India or acknowledgement of allegiance or adherence to a foreign state. Citizenship of India is a fundamental and essential qualification. Additionally, a person shall be disqualified for being chosen as and also for being a member of any house if he is not a citizen of India or has voluntarily acquired the citizenship of a foreign state or is under any acknowledgement of allegiance or adherence to a foreign state. Statutory disqualifications. Statutory disqualifications. In addition to constitutional disqualifications, the Constitution has empowered Parliament to lay down such other disqualifications for membership of state legislatures as it considers and deems appropriate. The statutory disqualifications are mentioned in Chapter 3 of Part 2 of RP Act 1951. Section 8 is about conviction for certain offences. Section 8A, commission of corrupt practices. Section 9, dismissal from government service for corruption or disloyalty. Section 9A, contract with appropriate government. Section 10, holding office under government company. Section 10A, failure to lodge account of election expenses. Disqualification under Section 8. Conviction for offences mentioned in Section 8 of RP Act 1951 by trial court attracts disqualification. Release on bail does not remove disqualification unless conviction is also stayed during pendency of appeal. Please note the difference between release on bail versus stay on conviction. Disqualification under Section 8(1). Disqualification commences from date of imprisonment and shall continue during the period of imprisonment till further period of 6 years since release from prison. Offences and period of imprisonment for disqualification. On conviction for offences mentioned under Section 8(1) of RP Act 1951, disqualification for 6 years even if there is no sentence of imprisonment. Offence of promotion of enmity between different groups on ground of religion, race, place of birth, residence, language, etc. and doing acts prejudicial to maintenance of harmony. Bribery or undue influence or personation at an election. Offence of making statement creating or promoting enmity, hatred, or ill will between classes or offence relating to such statement in any assembly engaged in the performance of religious worship or religious ceremonies. Offences relating to rape, offences of cruelty towards a woman, offence of preaching and practice of untouchability, offence of importing or exporting prohibited goods, offence of being a member of an unlawful association, offence under Foreign Exchange Regulation Act 1973, offence under Narcotic Drugs and Psychotropic Substances Act 1985, offence of committing terrorist acts, offence under Prevention of Misuse of Religious Institutions Act 1988, offence of conversion of a place of worship. Offence of promoting enmity between classes in connection with the election, offence of removal of ballot papers from polling station or booth capturing or fraudulently defacing or destroying any nomination paper, offence of insulting the Indian national flag or the Constitution of India, offence of preventing singing of national anthem. Disqualification under Section 8(2). Offences and period of imprisonment for disqualification. On conviction for offences mentioned under Section 8(2) of RP Act 1951, disqualification only if there is sentence or imprisonment for minimum 6 months. Hoarding or profiteering, adulteration of food or drugs, provisions under Dowry Act. Offences and period of imprisonment for disqualification under Section 8(3). On conviction for any other offences, minimum imprisonment of 2 years only will result in disqualification, other than as mentioned in Section 8(1) or 8(2). Disqualification under conviction for more than one offence in a common trial. In case of conviction for more than one offence in a common trial, and with the sentences of imprisonment to run consecutively for the purposes of Section 8(3) of RP Act 1951, the period of sentence of imprisonment for each offence should be added, and if the total length of time is 2 years or more, the convicted person shall be disqualified under Section 8(3) of RP Act 1951. Disqualification under Section 8(a). Disqualification on ground of corrupt practices as mentioned in Section 123 of RP Act 1951 in election arises out of order passed by the President on the opinion tendered by ECI. List of such disqualified persons, if any, is circulated by ECI from time to time. A person found guilty of a corrupt practice in an election may be disqualified for such period not exceeding 6 years. RO must check the updated list of disqualified persons and also note the time period for the disqualification as mentioned in the list. Disqualification under Section 9. A person who, having held an office under the Government of India or under the government of any state, has been dismissed for corruption or for disloyalty to the state shall be disqualified for a period of 5 years from the date of such dismissal. Dismissal from government service. A candidate dismissed from government service within the last 5 years must produce a certificate from ECI that he or she was not dismissed for corruption or disloyalty. Filing of certificate. Such certificate must be filed with the nomination paper, otherwise nomination shall be rejected. Disqualification under Section 9(a). A person is disqualified if the person subsists a contract in the course of his trade or business with the appropriate government. Appropriate government means central government in the case of election to parliament and state government in the case of election to state legislature. Contract should be subsisting on the date of scrutiny of nominations. Contract should be either for supply of goods to the government or for execution of works undertaken by the government. Contract with appropriate government. Where a contract has been fully performed by the person or contractor and there was delay in the payment to him by the government, the contract shall be deemed not to subsist. Contract. Performance of services. A contract for the performance of any services undertaken by the government is no longer a disqualification. Objection under Section 9(a) of RP Act 1951. ECI instruction number displayed on the screen dated 13 February 2017 may be referred to in case of objections against nomination under Section 9(a) on the ground of subsisting contract with government. Meaning of contract. As per Article 299 of Constitution, contract means any such contract by the union or state government expressed to be made by the President or by the Governor of State as the case may be, and shall be executed on behalf of the President or the Governor by such persons and in such manner as he may direct or authorize. Meaning of contract in Honorable Court's opinion. In Kanappa Rudrappa Nadgoda vs. Vishwanath Reddy, the Supreme Court held that a contract for construction of roads and buildings was signed on behalf of the government by an executive engineer and not by secretary to the government, and thus it did not comply with Article 299, but it was held operative against the contractor insofar as his disqualification under Section 9(a) of RP Act 1951 was concerned. In Mangilal vs. Krishnaji Rao Pawar, the Supreme Court held that a company registered under the Indian Companies Act is a separate entity distinct from its shareholders. The chairman of the board of directors of the company, while functioning as such, cannot be said to be engaged in his trade or business as contemplated by Section 9(a) of RP Act 1951. In Shivamurthy Swami Inamdar versus Agadi Saganna Adanappa, Ranjit Singh versus Harmohinder Singh Pradhan, the Supreme Court held that a contract by the chairman of a cooperative society with the government was held not to be contract by the said chairman in the course of their trade or business, as it was entered into on behalf of the cooperative society, which was a separate legal entity. In Kanappa Rudrappa Nadgowda versus Vishwanath Reddy, the Supreme Court held that a contract by the government with a partnership firm will disqualify the partners of the firm. If there is a private dissolution of the partnership without any notice to the government, it will not absolve the partners of such dissolved firm of their liabilities under the contract with the government, and partners will continue to be regarded as disqualified by reason of the contract with the government. Disqualification under Section 10. A person is disqualified for the membership if, for so long as he is a managing agent, manager or secretary of any corporation or company in the capital of which the appropriate government has not less than 25% share. Only secretary, manager or managing agent of government company is disqualified. Government company means any company, corporation, etc. in which appropriate government has not less than 25% share and does not include cooperative society. Appropriate government means central government in the case of parliament and state government in the case of state legislature. Disqualification under Section 10A. A person is disqualified for 3 years from date of order if he or she fails to lodge account of election expenses within the time of 30 days from declaration of results. In Shivram Gowda versus T.N. Chandrasekhar and Umlesh Yadav versus ECI, the Supreme Court held that the question of correctness or falsity of the account of election expenses maintained by the candidate under Section 77 can be decided by the Commission within the purview of Section 10A of RP Act 1951. Please go through the list of disqualified persons in respect of our state carefully. ECI can reduce the period of disqualification in certain cases by a speaking order, copy of which will go to CEO. Accordingly, RO to coordinate with CEO. In this video lecture, we have discussed about the qualifications and disqualifications from council constituencies in State Legislative Council election. If you have any doubts or queries related to this video, you can contact through the mail address as shown on the screen. For more election related material, you can visit the web address as shown on the screen. Thank you.